Hi, and welcome to a presentation on landlord tenant law. We're going to talk about what we need to know about our rights and responsibilities as a renter. At some point during your life, we need to move out of our parents' home and we'll probably start renting first before we buy, most likely. And there's some things we need to know to be ready to be a good tenant and understand what to expect from our landlord. There's a lot to know about being a tenant. So there are several topics that we're going to discuss today. First, we're going to talk about some resources for locating an appropriate rental and what to know about applying for being a tenant. We'll discuss rental agreements, the difference between leasing and renting month to month, and what you need to know about security deposits so you can make sure you get that money back. We'll go over the landlord's rights and their responsibilities to tenants, as well as the tenant's rights and your responsibilities as a tenant. We'll talk about eviction and other ways of breaking a rental agreement, and then discuss the best practices of how to move out and get your security deposit back. Well, finally, we'll follow up with just some resources for tenants in case you've had a bad rental situation. We'll talk about where to turn. So let's get started. The first thing we need to talk about when we're talking about renting or leasing are the players. The person who is renting a home or an apartment for a fixed period of time from someone else. Those are the tenants, the people that are going to live in that rented space. The landlord is the person that owns that rented space and provides that dwelling for others to live in. Each has their own rights for their position and responsibilities that go along with their role. And it's important to understand those things so we can have a positive relationship as landlords and tenants. When you're looking to live on your own, you have a decision to make whether you're going to rent or to buy. Not everyone is in a position to buy a home, or not everyone wants to. Sometimes there's a benefit to being able to call someone and saying, hey, your water heater broke, you need to come fix that, instead of you making sure that it being the one responsible for that. And sometimes we are more transient, and it might not behoove us to buy a home and be locked into a mortgage for a specific period of time, depending on our life circumstances. So if you've decided that you're going to rent, you want to know some things before you start looking for a rental place. Like, what is the average rent in your area? What do people pay on average for what size locations? So you can find that out by going to various sources like the newspaper or rental websites and seeing, what the average asking price is for the size dwelling that you're looking for. Maybe 1 bedroom, 2 bedroom, more than 1 bathroom. Maybe you need an outside building or a garage. Whatever your circumstances, do some searches and see what the average is in your area, so that when you're specifically speaking with someone about a property, you have that information to negotiate with. Also, real estate offices, sometimes we don't think about them when we're looking to rent, because we think of real estate as buying a home, but lots of real estate establishments will manage rental properties for people who own homes and maybe don't live in the area or don't want the hassle of being a landlord. So you can contact local real estate offices and see what properties they might have for rent. Also, if you're looking to find out, so you know how much the average rent in your area is, how much do you have in your income to put towards a rental fee? So you can go to a cost of living calculator at the website you see on your screen at bankrate.com, and that might help you to understand how much you have available in your existing budget to pay rent. That'll help you decide whether you can live in a place on your own or if you might need a roommate, or it might tell you what size location you are really searching for. And remember, you don't want to fall in love with that 5-bedroom house with a pool and a 2-car garage if that's not in your income level. So when you find that location that you want to live in, you might be asked to complete an application for a rental space. Um, there's some things that you're going to need to know about filling that in and about being what they're looking for in a tenant. So some of the things that you can expect is for the rental location, the landlord to do a credit check and look for any bankruptcies. They want to know, how well do you pay your bills? Are you likely to pay the rent on time? Or does it look like from your past financial history that they might have a problem getting you to pay the rent on a regular basis? That's important for them to know because just like you, your landlord is trying to protect themselves from loss. They also want to know about your employment. Do you have a job? Do you have any income that can pay the rent? That's important for them to know as well. They want to know also if you rented in the past and how has that rental relationship gone? Have you left on good terms your previous rental properties, or have you had to be evicted, and why? That's important for them to know to make a decision on whether they want to rent a space to you, because they have the right to deny you for certain situations, and we're going to talk about that in just a second. They might ask you for references. So that's another reason to make sure that you have a positive rental experience with past landlords so they can provide you a good reference for future locations. Each tenant, adult tenant who will be on the property, will need to be included on the application, listed on the application, and there will probably be an application fee that is not refundable. So keep that in mind if you know that you may not be or may not have the best tenant history. You may not want to rent from a place that requires an application or an application fee. You might want to look for a private rental situation. But there are cautions about that as well. We'll go into that. As I mentioned, a landlord or a management company has the right to deny you a place to live based on certain criteria. Those legal criteria include having a poor credit history or insufficient income for the rent that's required, maybe bad references that were found, or a discovery of past destruction of property that would prevent someone legally from allowing you to live in their dwelling. If the number of people who you expect to live in that dwelling would exceed occupancy limits for that city or county area, they can deny you a place to live. For example, if you want to put 4 adults and 4 children into a 2-bedroom apartment in the unincorporated areas of St. Lucie County, Florida, that would not be allowed according to county statutes. However, it is illegal for someone to deny you a place to live based on your race, your religion, your ethnic background or national origin, your sex, your age, the fact that you have children, unless the community has a stated senior housing community. Some places are 55 and older, and they have the right to do that. You cannot be denied a place to live because of a physical or mental disability. However, in some states, just a handful, you can be denied based on your marital status or sexual orientation, and hopefully those states are fixing that. Florida is not one of those states. Whether you're leasing or renting, there are some basic facts that you need to know before you even complete a rental agreement. You want to know what the required rental period would be. Is it month to month? Open and ambiguous? Or is it a stated period of time, like 6 months, 1 year? What will the amount of rent be for that stated period of time? And what's the required security deposit? Sometimes when you look at advertisements for rental property, you'll see the statement FLS followed by a dollar amount. First, last, and security is what that stands for. That means that the landlord requires, upon the rental agreement, for you to pay the first month's rent, the last month's rent, and the security deposit. That's a big chunk of upfront funds, and you want to pay attention to that so you're prepared to pay that money. A month-to-month rental agreement is pretty flexible. It's for an unspecified period of time. The rent's usually payable on a monthly basis, usually the first of the month. And it's nice because it provides flexibility if you're not sure how long you're going to be staying in an area. Unfortunately, it's ambiguous because the rent or rental rules can change at any time. From month to month, your landlord could say, thanks for the rent this month. Next month, it's going to be $25 higher. And it's your choice to either stay or pay. The landlord at any time could say, hey, you know what? I told you utilities were included, but starting next month, I'm going to need you to pay your own electric bill. Without a lease in place, those things can happen. So there is protection from a lease agreement, a rental agreement. There's flexibility with a month-to-month. Depends on your situation and what works for you. A lease agreement is a more formal contract that states all the parameters of the rental agreement. It requires a tenant to stay for a specific amount of time and puts the liability on the tenant if they do not stay for that time commitment. The benefit is that both the tenant and the landlord know the terms of the rental agreement for that period of time. Things cannot change. The lease is what it is for that stated period of time. So you have some security and some assurances about the rental relationship. As I mentioned, a lease agreement is a contract. Be prepared to sign that contract and be held to the terms of that contract. Before you sign it, you want to make sure that you understand everything that's in it, every word. You want to read it before you sign it for sure. Request a copy of the lease agreement in advance. If you think that is where you would like to lease, you can review it at your own pace and take the time to understand the language, because sometimes rental language, the lingo, is not common language. The party of the first part and the party of the second part can be confusing when you're reading that. But do as you read it, if there's anything that doesn't make sense to you, be sure to talk to your landlord. Keep in mind, it's their lease. They should be able to explain all the terms of that lease. If they can't explain to you why a certain term or parameter is in that lease agreement, then that's a big red flag to you that may not be the landlord that you want to have a relationship with. Keep that in mind. Because remember, once you sign it, you're liable for it. And what do I mean by that? Well, I mentioned that a lease agreement is time specific. So what if you sign a lease for 12 months and after 6 months you get a new job opportunity and you have to move to a different city? You are liable for the remainder 6 months. Now you probably paid first, last, and security, so the last month is already paid, but there's 5 months of rental payments that landlord is expecting according to that contract. And we'll talk about what happens if you have to break the lease before the time period is up, but bottom line is you're responsible for those unused months because the contract says that the contract holds you to those terms. As you read and review the rental agreement, you want to make sure that you note the length of the tenancy. How many months do you plan will you be required to pay the rent there? And what is the amount of the rent? And what is the security deposit that you'll have to pay? Do you have to pay first, last, and security all at once? Not all landlords require FLS. Some require just FS, first in security. The rental agreement should state the number of people who are allowed to live in that rental property space. What's the occupancy limit? It should outline who is responsible for paying for utilities, whether you're allowed to have pets of any kind or certain kind in that rental space. A rental agreement will also let you know if you are allowed to sublet the property. Our previous example of what if you signed a 12-month lease and have to leave after 6 months? If your lease agreement allows you to sublet the property, you can find someone else to live in that space for the remainder of your lease. You want to make sure that you know if you are allowed to do that or not. The rental agreement should also state the landlord's expectation for their access to the rental property. There are state laws that outline that, but if the landlord has any changes to that access law, then they have to state that in their rental agreement. And also they'll want to, if there's a negative situation, rental situation, the rental agreement should explain who's responsible for paying any attorney fees that result from that. And just a quick example, I leased a place that in the rental agreement it stated that the landlord would be coming into my space periodically for repairs. They would let me know in advance. However, if they came into my space and found that my shower curtain was squished up or not spread out so that the shower curtain would dry, I would be facing a fine because allowing the shower curtain to not dry easily by opening it completely, spreading it out, would cause mildew and mold, which cost the landlord money. So they included in their rental agreement the requirement to make sure that we as tenants did not cause mold and mildew in the bathrooms by using our shower curtains properly. It's pretty specific, but they were adamant about that, and I was okay with it. Just as an example of what you could see in a rental agreement. What you should never see in a rental agreement is an edit that explains that you are giving up your right to defend yourself in court should that rental relationship turn negative. Also, you should never see any wording that limits the landlord's liability for things that they're normally responsible for, the things that the state requires a landlord to provide. So those are the things to watch for, and we're going to talk next about what those things actually are, because there's quite a few. Before we get to that though, let's just talk for a minute about security deposits. How much can a landlord charge for a security deposit? It varies by state, and in Florida, there is no stated limit. Why is that? Well, usually the law of supply and demand sets the limit. If a landlord is asking for too high of a security deposit, they probably won't get that many tenants applying. If they're asking for too low of a security deposit, they might have way too many people applying and maybe not the caliber of tenant that they're looking for. So the market sets the price on security deposits, but usually they're not more than 1 or 2 months of rent. When does the landlord have to return the deposit? That also varies by state, but in Florida, they're required to return the deposit within 15 days of you vacating the property. You must provide them a place to return, the information to where to return that deposit to. And if there's any reason for them to keep all or part of the security deposit, they have to let you know within 15 days that they're going to do that and explain to you what they saw that caused them to keep that deposit. And we're going to go over those situations as well in just a moment. So how do you protect you and your security deposit? You want to make sure you get all that money back, especially if it's 1 or 2 months rent. So ask someone to walk through the rental property with you when you go to look at it. Take notes on what you see that may be damaged or some wear and tear that you note. You can take pictures of everything that you see and print them out and include them with the lease when you sign it and give it back to the landlord if you've decided that that's where you want to live. Go through a rental checklist. There are several available online, things to look for, and you could provide a copy of that rental checklist to your landlord with this signed lease agreement, just so both of you know the condition of that property before you moved in, and there's no question. So you want to note any damage that you see, any wear or tear on the lease. You can attach photos or write in the margins, whatever it is, but make sure you get a copy of that lease once it's signed as well. So if someone, your landlord, is going to offer a dwelling for some other people to live in, they have a responsibility to provide certain maintenance, but not all. In Florida, a landlord is responsible for providing weatherproofing. They have to make sure the windows can close or are not broken so that the weather can stay outside, not inside. They have to make sure that heat is available. In Florida, that's kind of ironic because they do not have to provide that cooling is available, just heat. They have to make sure that water and electricity are accessible. They don't have to provide water and electricity. That may be the tenant's responsibility to establish a utility account and pay the deposit and have those utilities turned on. But it's the landlord's responsibility to make sure that that water, once the utilities are turned on, can get from the water pipes, city water pipes, to the dwelling. Same with electricity. Do you understand the difference there? The landlord is responsible for providing a clean, sanitary, and structurally safe home. That means mold and mildew. It should be absent before you move in. The place should be clean, structurally safe. If doors are not closing properly, if windows cannot be locked, or if the porch is falling down above the front door, that's a big red flag that this landlord is not meeting their responsibilities, and you may not want to even move in there in the first place. It is the landlord's responsibilities to make sure that there are smoke detectors in the home. It's the tenant's responsibility to make sure that those smoke detectors' batteries are working on a regular basis. It's the landlord's responsibility to make sure that you have security. There are locks and keys to the doors of the dwelling. They do not have to change the locks and keys between tenants. Something to think about. You may want to request that, but they have to provide security of some kind. It's your responsibility as a tenant to think about what kind. And if you happen to change the locks, it's your responsibility to make sure that the landlord does have a key to their own dwelling. They have access. You as the tenant have maintenance responsibilities as well. They have to provide access to utilities. You're responsible for paying them if the lease agreement states that. And you're responsible for paying your rent on time. We're going to talk about what happens if you don't. It's your responsibility as a tenant to comply with local ordinances, like noise ordinances. If there's an ordinance in your area that says there shouldn't be noises louder than a certain decibel after perhaps 10 p.m. or 11 p.m. at night, it's your responsibility as a tenant to comply with that. If there are restrictions on operating a business out of a residential location, you want to make sure you know about that if you intend to do something like that, because it's your responsibility to comply with those local ordinances. You're responsible for keeping the unit, the home or the apartment, clean and sanitary. You are responsible for disposing of garbage properly and respecting common areas like lobbies, garages, and pools. You're respecting other people's right to also use the property. Just a few more responsibilities for tenants. How about making sure that we're properly operating the appliances and features of that unit, like the heating, the plumbing, and the electrical system. That means not flushing diapers or non-flushable items in the plumbing and causing the landlord to have to make repairs. If they find that you flushed something that shouldn't have been flushed, they're going to charge you with that bill. I have an example of irresponsible use of home systems. My father came to visit me here in Florida from Utah in August. He was not accustomed to that heat that he was feeling, and the thermostat for our HVAC system was right outside the spare room where he was sleeping. He got up in the middle of the night and put that thermostat down on 61, 62, somewhere around there, as low as he could get it. We got up the next morning and it felt really hot and humid in our home. Opened the closet door where the inside unit HVAC unit was and saw that there was a sheet of ice over the front of the unit. Because he had dropped the temperature so low, it caused the whole system to freeze up and not be able to be used until that actually thawed, and we had to have a repairman come out and check the system. So that was an unintentional improper operation of our HVAC system. And as a tenant, if he had been a tenant, yes, he would have been responsible for that repair on our HVAC system. But unfortunately, he was my dad, and I love him, and I can understand how different the climate is between Utah and Florida. So we don't want to intentionally or carelessly damage a dwelling. If we break a window, it's our responsibility for fixing it. Even though it's the landlord's responsibility to make sure there's weatherproofing, if we damage that weatherproofing carelessly, we're responsible for fixing it. And we don't want to interfere with other tenants' use of the property. We talked about the pools and garages. You want to, if you have kids, make sure they don't leave their bike on the condo walkways and cause other people to have to trip over them. Be considerate to other people when using the pool. Make sure that you're allowing other people their space as well around all the amenities that might be included in your rental property. And bottom line, it's your responsibility as a tenant to return that unit to the same condition as when you moved in, minus normal wear and tear. Let's talk. I had mentioned about protecting yourself from loss. And if you're going to put your belongings in someone else's property, someone else's dwelling, renter's insurance is a really good way to protect yourself from the loss of your belongings. The landlord, the property owner, has insurance that covers their dwelling. Their property insurance covers the walls, the roof, the actual property, not the belongings inside that property. So you, as a tenant, want to make sure that you have insurance that covers your belongings in case there's a fire, a theft, or some sort of natural disaster that could damage your belongings. Policies are relatively inexpensive for renter's insurance, and you can get a policy that has a deductible as low as $250, can go up to $1,000. The lower the deductible, the higher the cost of the insurance. Keep that in mind. And you want to put a value on what your belongings would cost to replace. So make sure that you think about, what is the value of all the belongings that you've moved into that person's dwelling. And each of the tenants that live in that location should have their own renter's insurance unless they're legally married. So if you and a roommate are sharing space, each of you should have your own renter's insurance policy to cover your belongings. Keep that in mind. So we talked about the landlord's responsibility to make repairs. And in order to do that, that person is going to need to enter the property. State law requires a certain amount of notification for a landlord to enter the property, whether you're going to be on there or not. They must give you notice. It varies by state, the amount of notice, but in Florida considers 12 hours reasonable notice. So if your landlord wants to come in first thing in the morning to make repairs or update a sink faucet, they need to let you know by the night before. You can't refuse access. It is their property, and they have the right to come onto their property. However, they do need to let you know that they intend to do that. They may need to show the property, perhaps they're selling it, they may need to make repairs. However, no notice at all is needed if there's an emergency, like a fire. Yeah, they're not going to give you 12 hours notice before they come in and put out the fire, right? Or a serious water leak. 12 hours of water leaking is really going to damage the property. So that's an emergency where they need to enter right away, and you should expect that. And abandonment. If you have left the property for more than half the rental period, meaning if you pay your rent every month and you've left the property for more than 14 days, 15 days, somewhere in there, depending on the amount of the days in the month, and have not notified your landlord that you'll be gone, the landlord could declare that you have abandoned the property, and they have the right to enter once it's declared that you've abandoned the property. So you really want to communicate to your landlord if you plan on taking a really long trip. Make sure that they don't think that you've abandoned and they go in your property with no notice. And I just want to add that this whole presentation came about because I was making a financial, I think I was talking about budgeting to a group, a ladies group, and they started talking about renting and how they were all sharing stories about coming out of the shower and finding their landlord sitting on their couch watching TV or doing something, that they didn't expect. But they all had stories about unexpectedly finding their landlord in their home. And I just want to stress that that is not allowed. That is not acceptable. Notice is required. And you cannot refuse, but you should know when someone expects to be in their property that you're renting from them. It's never acceptable to unexpectedly find your landlord in your home. Now, speaking of repairs, it's important to know what to expect if you need a repair. Well, number one, put your request in writing so your landlord can't say that they didn't get that. Send them an email with a return reply request, whatever that phrase is, that makes you that so you know that they opened it, or send them a certified letter, some way that you have proof that you notified them that there was a repair needed, and then give your landlord time to respond to that notification. Response times vary by state. But generally, in Florida, your landlord must reply to your notification of a needed repair within 24 hours if this has to do with an emergency situation like no water, no heat, no electricity, or other hazardous or life-threatening condition. Those items that are required to be provided by a landlord, heat, electricity, water, access to, they need to fix that they need to notify you about how they're going to fix that within 24 hours. And take note of those words. A response time. That doesn't mean they have to fix it within 24 hours. That means they have to reply to you within 24 hours of you notifying them of the situation to let you know what they're going to do about it. And if it's a non-emergency situation, maybe it has to do with a broken refrigerator, your oven's not working, or some other major appliance, the wash machine broke down, something like that. Maybe there's a plumbing clog, but you can still use another bathroom. That they have 72 hours to respond to your notification of a need for repair. If it's just a minor repair, hey, the switch plate fell off the living room light switch, well, that's minor, and they can respond to your notification within 10 days for those kinds of minor repairs. But keep in mind, response is not repair. They have to let you know what they're going to do about it within those time frames. Not that they have to fix it, just respond to your notification. So what if you notified the landlord properly? They responded to you within the right period of time and said, oh, yes, we understand that your toilet's clogged and we're going to fix that in the next 2 days. And then they don't. And they don't. And you notify again and go, hey, nobody showed up. Well, that happens, unfortunately. And you have rights. There are ways to compel your landlord to do what they're supposed to do. So your options are make the repairs yourself and pay less rent. But don't do that without agreeing to that up front with your landlord. Call them and let them know, hey, the toilet's clogged, but I know how to fix it. It just needs this little part, or I need to rent a snake or something to run down the pipes, and it's going to cost this much. Can I take that out of the rent? Yes, you can. Get approval for that, possibly in writing. Might be good to get a paper trail for that. Depends on what kind of relationship you have with your tenant or your landlord. But, that's an acceptable resolution to the situation. You can also agree with your landlord that you'll hire a professional and deduct the cost of the repair from the rent. But make sure you know that you agree to that up front. Surprising your landlord with that kind of a situation is not recommended and will probably not end in your favor. You do have the right to withhold the rent if the landlord is not making the needed repairs. However, you have to follow the right guidelines. You do have to pay your rent, and you'll be paying that to the clerk of the court in your county. And then you will notify your landlord that the rent has been paid to the clerk of the court, who will release the funds to them on proof that the repairs have been made. Simple as that. You have every right to do that, and that's your option. You can call the building inspector and say, look, I have asked for them to fix the support for this front roof over and over again, and this thing is going to fall down on my head. Would you come out and make sure that it's safe for me to live here? If the building inspector comes out and says, oh my heavens, no, this is not safe, you cannot live in this dwelling until these repairs are made, guess who has to pay for you to live somewhere else until their repairs are made? Your landlord. They'll pay your hotel bill, or they're supposed to, until they make the repairs. It's a really good motivator for them to make sure that they get those repairs done on time. That is your right. You can take it next step further and mediate, or go to court over it, small claims court, for the cost of the repairs you made without getting approval in advance and then withholding from the rent. You don't want to end up in that situation if you can. And then bottom line is, you can just move out with the proper notice. You go, you know what? This is not the landlord for me. This person is not responsive, and I'm just tired of dealing with the problem. I'm going to find somewhere else to live. Those are your options if your landlord is not responsive to making the repairs that they're responsible for making. Of course, this varies by state. These options are general, but applicable to Florida. So landlords have the right to remove you if you are not meeting your responsibilities as a tenant. If you're not paying the rent, they can start the eviction process. Even if you are just 1 day late with the rent, they can start the eviction process. Eviction is not immediate. And it is not self-help in Florida. It does require a assistance from the sheriff's department, but they can start the process the day that your late is officially rent, or your rent is officially late. Um, if you're not complying with the terms of the rental agreement, the landlord is required to give you a 7-day notice to comply, and state that if you don't, they will start the eviction process. And if you've, like I mentioned before about abandonment, if you're gone from the dwelling for more than half the rental period without paying the rent or giving written notice of your absence, the landlord has the right to assume that you've abandoned the property and has the right to do with whatever they want with your belongings that are still in the property, on the property. And they have the right to enter and see what you have left. So keep in mind, those are the things you can do to cause an eviction to happen. As I mentioned, Florida prohibits self-help evictions. A landlord can't just say, I want you out of here. A court order is required. So if you have received that court order that and stayed in the dwelling past the stated days that's noted on that court order, that means you've refused to vacate the property. That allows the landlord to now change the locks on you. They can put a lien on your possessions, and what they'll do is they have the right to move your belongings to the property line where they are no longer responsible for what happens to them. I don't know if you've seen this on the side of the road, but I have a whole house worth of furniture and clothing and accessories all right out there at the property line, and everybody in the neighborhood picks through and picks out what they want and leaves the garbage men to pick up the rest. You don't want that to happen to you, and that's what the landlord will do if you have received a court order about an eviction and you have not complied with the time constraints on that court order. So until the time frame on that court order for eviction is up, there are certain things that a landlord cannot do. Even if you're behind on the rent, but the eviction court notice has not run out yet, you still have time, it's illegal for the landlord to lock you out before that time. They can't change the locks until after the date on the court order has passed. They can't shut off your utilities until after the date on that court order has passed. They cannot take your property out of your home or take it anywhere unless, like we talked about, the abandonment situation. And they cannot take retaliatory actions against you, like blocking your car in from letting you leave because they're just trying to make life tough on you, make things harder for you. That's childish, actually, and not legally allowed for landlords to do. If you have a situation like that happening, make sure that you're documenting those situations. So in case you need that backup, you have a record of what was done. In some situations, the tenant may want to break the lease. You get into a lease agreement and things aren't working out. Maybe the landlord is not making the repairs that you expect them to make. You've notified them properly and they are still not doing it. Your choice is to leave. You have a right to break the lease legally if you can document that the landlord has failed to make the repairs as required, or if they're failing to comply with health and safety standards, such as not eliminating mold that you might have found behind the walls or something like that. If you have to break the lease, as I mentioned before, you still are responsible for the remainder of the rent under the lease term. that example of signing a 12-month lease and wanting to leave after 6 months, you are legally responsible for that 6 months rent that's still owed under that contract. However, keep in mind, the law says that the landlord has a duty to find a new tenant for that space. And once they have a new tenant in that space, your responsibility has ended. So maybe that dwelling that you left after 6 months, your landlord is able to rent it out 2 months later after you've moved out. So you may have to pay rent for 2 months, but once there's a new tenant in that space, the landlord is now collecting rent from that tenant and you are no longer liable. The landlord has a right to break the lease as well. If you're not being the tenant that they expected, maybe you're not paying your rent on time on a regular basis, or maybe you've broken the lease agreement by having a pet that was not allowed. The landlord has to give you time to fix that situation, maybe rehome that pet or fix the damaged property that was damaged that they're not responsible for. But if you have not complied with that situation within the given time, then the landlord may ask you to leave. And in this situation, it would either be by an eviction notice or a request that you leave, and with the understanding that you are no longer responsible for the rent under the remaining months of that lease. If you're renting at some point or another, in some way or another, you're probably going to move out. If you're doing that the right way, you're providing written notice to your landlord. And written notice has a time limit, a time requirement. If you're renting week to week at a location, then written notice is 1 week, 7 days. If you're living month to month in a rental property, Florida law requires 15 days notice. If you're renting by the year, which I'm surprised to find out some people actually do, they pay their whole year's rental fee all at once. Kind of neat that way, then you don't have to worry about it all year. But if that's your situation, state law requires 2 months notice, 60 days notice before you leave the property. Your landlord has to have an idea or has to know that you plan to leave that space. If you have an actual lease agreement, the notification process for your landlord is spelled out in that lease agreement. You want to pull that document and see what you're required to do. And as I mentioned before, if you're leaving before the end of the lease term, then you would be responsible for paying the rent for the remaining lease term, unless the landlord can rent the unit out, and once they do, then you're not responsible anymore. Whenever you leave a dwelling at the end of your rental situation, you want to make sure that you leave that dwelling in the same condition as when you moved in, except for normal wear and tear. Heavy traffic areas on the flooring, it's expected. Maybe scratches on the lock from your key, that's expected. That's normal wear and tear. Anything past normal wear and tear should be repaired so that you can get your full security deposit back. If you've hung pictures on the wall, make sure you fill those holes from the nails so that you can get your security deposit back. If your landlord has to fix all those little holes in the wall that you made, they can bill you for that. And we talked about it earlier, they have a certain number of days to notify you, 15 days, to either get your deposit back to you or notify you why they're keeping all or part of your deposit. And if they have to repair those little holes, they can take the cost of the caulking and the labor to apply that caulking and the paint to paint over those that caulking, and to your security deposit, and that takes money away, and they may find enough repairs to keep your whole security deposit. You don't want that to happen, right? You want your deposit back, so make sure you leave that dwelling in the same condition as when you moved in. Take care of those little minor fixes so you can get your money back. In a rental situation, it's ideal if both parties, the tenants and the landlords, behave as they're expected to. Everyone knows their rights and everyone meets their responsibilities. Unfortunately, that's not always the case. So the law says that if someone has property that they own and they're willing to let someone else live on it or in it, there are certain requirements that they must meet. If that person is not meeting those requirements, you as a tenant can contact your attorney general's office to find out what your recourse might be. You can notify your housing and urban development department, or one really great resource just to let you know where you stand as a renter in Florida is the Florida Renters Handbook, which can be found at the website on your screen, www.floridapirg.org. Most of the information from this presentation came from the Florida Renters Handbook. I've summarized it for you, but the details and the actual statutes can be found in that handbook, and you might need to reference that at some point or another if your landlord is not behaving the way the law requires. You have options. Wow, so we have been through the rental process from start to finish and all through the middle, right? We've talked about rental terms, landlords, tenants, and security deposits, things like that. We've talked about rental agreements, what to expect, and what to expect from your landlord. The rights that you have as a tenant, your responsibilities as a tenant, the landlord's rights and responsibilities, and how to properly move out, whether you're doing it voluntarily or involuntarily. And lastly, we talked about where to go for help in case your rental situation is not going according to terms. We hope that that doesn't happen to you. We hope that your rental experience is a positive one and you can share that with others. I hope that the information you learned from your county extension office has been beneficial to you, and we look forward to you joining us for future presentations on all kinds of financial life skills. Thank you.